Hello and welcome to Connected with Latham, where we discuss ideas, legal developments, and business trends shaping the global economy. This is the third episode of the Latham & Watkins Drug Pricing Podcast, and I am Chris Schott, a partner in the healthcare and life sciences practice in our Washington, D.C. office. I focus my practice on manufacturer compliance related to the Medicaid Drug Rebate Program, Medicare, and the 340B Drug Pricing Program. Joining me is Danny Machado, an associate in our Washington, D.C. office. Welcome, Danny.
Hi, Chris. Thank you for having me. Great to join you on another episode.
In each episode, we will focus on a specific drug pricing topic, and after discussing the substance, we will ask the question, which Olympic sport is it like? And we have the list of Olympic sports here to see which most resembles the topic in terms of strategy, complexity, or frankly, level of conflict. And Danny, what is our topic for today?
Today's topic, Chris, is the recent Medicaid proposed rule that CMS released back in May. And we're going to spend particular time today focusing on the concept of best price.
Yeah, just to give some background, this regulation is designed to implement a statutory change that Congress passed back in 2019, which was called the Medicaid Services Investment and Accountability Act. And that statutory change gave CMS various new enforcement authorities, and that's the prompt behind this proposed rule. But CMS included various other topics in the proposed rule, and like Danny said, one of the key topics here is best price. And to remind ourselves, best price is a metric that manufacturers report as part of the Medicaid Drug Rebate Program, and it influences the Medicaid rebate for innovator products. And the longstanding statutory definition is that best price reflects the lowest price available from the manufacturer during the quarter to certain eligible entities, such as wholesalers, retailers, or providers. And Danny, what is the key change here in the best price reading that CMS is proposing?
Sure. So the best price in the Medicaid world is the lowest price that a manufacturer makes available in a given quarter on a single unit to a best price eligible entity. So now the question that we're faced with is, what if there are different discounts? And how does that get factored in, Chris?
Absolutely. And so maybe we give two examples to kind of illustrate the current reading as compared to the new reading that CMS is suggesting in the proposed rule. So the current best price stacking practice focuses on same unit and same customer. And a good example would be a PBM and a mail order pharmacy that's owned by the PBM. So in this hypothetical example, the manufacturer provides a discount to the mail order pharmacy and then also pays the PBM a rebate on the same unit. And so here we're satisfying both of these boundaries. It's the same unit that is getting both discounts, and both discounts are ultimately going to the same customer. Now, the different example would be the manufacturer sells the unit to a wholesaler. The wholesaler delivers to a pharmacy that's independent of the wholesaler, and the manufacturer has a contract with that pharmacy also for a price discount. And let's assume that the manufacturer gave a discount to the wholesaler. Now, in this case, in the current reading of the best price definition, we would not be stacking because we gave a certain discount to the wholesaler and an unrelated entity, the pharmacy, received a different discount. And because these two are not the same customer, we would not be stacking. It's the same unit, but not the same customer, so no stacking. And what CMS is telling us in the proposed rule would be the opposite. Basically, under the proposed rule, under both examples, there would be stacking.
Right. And one of the interesting things about the proposed rule is that CMS indicates that they are merely adding a clarifying statement on the best price definition in this case, right? Where, as you have indicated, Chris, this has not been the practice or the interpretation that either CMS or industry participants have adhered to in the past.
Yeah, and that's an excellent point, and it really is helpful in that sense to look at the comment letters, which are available on the reg.info website, and see how different stakeholder groups have responded to that. And I think those comment letters make pretty clear that the current view of best price stacking is the one that's been prevalent in the industry and also has been adopted by CMS in the past. So with the big stacking issue out of the way, let's talk about the IRA tie-in. And here it kind of makes sense to look a little bit at the best price statutory definition to remind ourselves how the IRA actually modified that. So if we look at the best price definition in the statute, there's first the definitional section that just defines best price as the lowest price available from the manufacturer. And then there's another subsection called special rules. And in the special rules section are a couple clauses that talk about best price aspects. And just for illustration, the very first one says best price shall be inclusive of cash discounts, volume discounts, and among other things, rebates. And Danny, how is that implemented today? In other words, if you're a manufacturer and you gave, let's say, a cash discount or a rebate, how would that factor, or when would that factor into best price?
Right. So in today's world and the way that it is understood, cash discounts would not automatically be included in best price. Instead, that provision, that subclause, right, those special rules are read in the context of the entire framework of the statutory best price, which provides that a price is eligible for best price only when there is a transaction that is eligible for best price, for instance, a sale, and where the entity that receives this price is an entity that is eligible for best price, right? So one of the entities that are eligible and enumerated in the statute, for instance, a wholesaler.
Yeah, that's exactly right. And so this is why when a manufacturer decides or filters in order to submit to CMS its pricing data, what is relevant for best price, those are the filtering mechanics that get applied, right? There's a class of trade filter. Is this a customer type that's relevant for best price? And there's a transaction type filter. A sale typically would be included, but other types of transactions, such as returns, would not be included. So while the statute on first glance says the term best price shall be inclusive of cash discounts, it is not an automatic inclusion of every single cash discount. It only is included if it's given to a best price eligible entity in a best price eligible transaction. And that takes us to how the Inflation Reduction Act amended the best price section here, because it added a subclause at the end that basically said in the case of a rebate period, in other words, a quarter, and a drug that is a selected drug, in other words, it's subject to price negotiation, the best price shall be inclusive of the maximum fair price for such drug. And the question becomes, if there is a drug that's been subject to negotiation and has a maximum fair price that applies to it, how is this inclusion supposed to work? And in the preamble to this proposed regulation, CMS includes one sentence where CMS states, we note that maximum fair prices that are negotiated for selected drugs would be included in Medicaid best price. So it's not clear how CMS envisions this inclusion, but the question becomes, should that inclusion work the same way as the other inclusions in the special rule section of the best price definition?
Right. And so the idea here is that this new subclause, subclause 5, should be read in the same manner as the existing subclauses in the past, just like with the cash discounts that we were mentioning before. If maximum fair price is in effect for a covered outpatient drug, well, it should only be included in that best price if it is realized in a best price eligible transaction and there is a best price eligible entity that receives that price.
Yeah, and so CMS, to our knowledge, has not addressed how this maximum fair price inclusion and best price will be implemented, other than making this short preamble statement. So it probably makes sense to monitor that carefully and see how CMS proposes to implement that in the future. And totally agree with you, Danny. My view of reading the statute would be that this maximum fair price inclusion should operate exactly the same way as these other inclusions, such that if you give a cash discount, let's say, to an entity in Canada, that would definitely not make it into best price. And similarly, the maximum fair price should really only be included in best price if it's given to a best price eligible entity on a best price eligible transaction. So I think with that, Danny, that takes us to our starting question. Which Olympic sport is it like? Danny, why don't you go first and tell us which sport you think this most resembles?
Okay, to our favorite part of the podcast. I'm going to pick a sport that is near and dear to my heart, which is snowboarding. And the reason is that in the late 1970s, Chris, snowboarders started to, quote unquote, invade traditional ski resorts. And skiers used to really hate when snowboarders started coming to their resorts. I think in this case, I see the Inflation Reduction Act starting to invade the world of Medicaid, right? The Inflation Reduction Act, the purpose is to negotiate drug prices in the Medicare world. But as we see here, the Medicaid best price is going to have some relationship to the maximum fair price in Medicare, such that Medicaid is going to be able to enjoy some of those benefits as well.
That's interesting because I also started in the world of winter sports. And like snowboarding, I picked a sport that requires risk-taking and daring, namely ski jumping. And like you were thinking of CMS invading as snowboarders, I'm thinking of CMS at the top of this ramp, trying to jump as far as it can possibly jump with this proposed rule, implementing a change to the best price definition while calling it a clarification. So we'll see how far that jump actually extends off the ramp, but looks like we're both here in winter sports world. Very interesting that we coincidentally came to that similar scenario.
Right, as we're in the middle of summer enjoying the heat, of course, thinking about snow.
Well, I think that nicely sums up our podcast. So, Danny, where are we going? Where's the after party?
I think today, Chris, I'm feeling in the mood for some French wine and food. There's a place in Georgetown. It's a few minutes away. We can probably get there really quickly. It's a place called Chez Billy Sud. And for our listeners, this is a small little fireplace created cozy French restaurant in Georgetown with great French wine and great French food. The burgers are amazing if anyone is particularly interested.
That sounds like a nice place and a nice walk. Wonderful.
Let's do it.
Thanks to Danny for joining me, and thank you to our listeners for checking out this third episode of the Latham & Watkins Drug Pricing Series, which is part of our Connected with Latham podcast. You can subscribe and listen to new and archived episodes of Latham's podcasts on lw.com, Apple Podcasts, Google Podcasts, Spotify, or anywhere else you listen to podcasts. If you have questions or would like additional information, please email us using the links located in the show description. We hope you'll join us again next time.
This podcast is provided as a service of Latham & Watkins LLP. Listening to this podcast does not create an attorney-client relationship between you and Latham & Watkins LLP, and you should not send confidential information to Latham & Watkins LLP. While we make every effort to assure that the content of this podcast is accurate, comprehensive, and current, we do not warrant or guarantee any of those things. And you may not rely on this podcast as a substitute for legal research and/or consulting a qualified attorney. Listening to this podcast is not a substitute for engaging a lawyer to advise you on your individual needs. Should you require legal advice on the issues covered in this podcast, please consult a qualified attorney. Under New York's Code of Professional Responsibility, portions of this communication contain attorney advertising. Prior results do not guarantee a similar outcome. Results depend upon a variety of factors unique to each representation. Please direct all inquiries regarding the conduct of Latham & Watkins attorneys under the New York's disciplinary rules to Latham & Watkins, LLP, 1271 Avenue of the Americas, New York, New York, 10020. Phone number 1-212-906-1200.